Double taxation relief. After studying this chapter, you will able to appreciate the need of double taxation relief, appreciate the types of double taxation, I will comprehend and apply the provision relating to the double taxation relief contained in the Income Tax Act 1961 and Income Tax Act 1962 in the probably solve addressing issues. Comprehending the procedures claiming the deduction where there is no double taxation avoidance agreement between India and other countries where the income has been taxed on a complete amount of taxation. Appreciate the concept of permanent establishment under the double taxation avoidance agreement and elements. Concept of double taxation relief. If the present area of cross-border transaction across the global, the effect transaction is one of the important consideration of trade and investment in other countries. One of the most significant results of globalization is the visible impact of one's country domestic tax policies on the economic of other countries. It has held the need of the continuous assessment of tax regimes of various countries of bringing together necessary reforms. And taxpayers are such in one country, but the source of income situation in another country gives impossible double taxation. The rising of two basic rules have enabled the country to residence as well as the country. A source of income exists on the imposed tax, namely source of rule or residential rule. The source rule is where the income is being taxed in a country in which originates, irrespective of whether the income accrues to the resident or non-resident. The residence rule stipulates where the power of the tax should be rest with the country in which taxpayer resides. The both the rule applies simultaneously in the business entity. It could suffer taxes on both sides. The cost of operation in international scale would become prohibited and would deter the process of globalization. It is from the point of view of double taxation avoidance agreement became very significant. The double taxation, the DTA, double taxation avoidance agreements lay down the allocation of rules of taxation in the income of the source of income source country and resident duty. The rules is laid in the various categories of income, for example, interest, dividends, royalties, capital gains, business income. Each category is dealt with the separate DTA. Double taxation means taxation some income twice in the hands of assessing. A particular income can be taxed in India in the hands of a person based on his or his residence. However, the same income may be taxed in his or hands and source of the country. Also, as a double taxation of the country, it gives rise to double taxation. The universally accepted principle that said same income would not be subject to tax twice. In order to take care of the situation, the Income Tax Act 1961 provides double taxation relief. Types of reliefs or double taxation can be provided in mainly two types: relief, bilateral relief, and unilateral relief. Under this government of two countries can enter into the agreement to provide relief against double taxation of mutual countries out to the basis of which relief is granted. India has entered into agreement to relief against avoidance of double taxation with almost 100 countries including Sri Lanka, Switzerland, Sweden, Denmark, Japan, federal regulation, Republic, Germany, Greece, etc. Bilateral relief can be granted in either one of the following method. Exempted method. A particular income is taxed only in one of the two countries, or two credit method. The income is taxable in both countries in accordance with the respective tax laws. Ahead of double taxation avoidance agreement. The country of residence of the taxpayer, however, allows his credit on the tax charge thereon the country of source. India follows the credit method in majority of the DTA and unilateral method. This method provides a double taxation relief unilaterally by the country in the residence of the taxes paid on other countries, even though there is no DTA has been entered into it. The India grants unilateral relief through credit methods under Section 91 of the residents of the taxpayer in the country, which gives India has not signed DTA. India has introduced a foreign tax credit rule, Section 128, which allows the granting credit to residents in the Indian tax paid in other countries. Double taxation relief provision under the Income Tax Act 1961. Section 90 and 91 of Income Tax Act 1961 provide double taxation relief in India. Agreement with the foreign countries and specific bilateral relief. Section 90. Section 90 provides that central government may enter into agreement with the government of any country outside India, specified territory outside India, for the granting of relief respectively the income on which income tax has been paid both in India and the country of the specific territory. The income tax chargeable under this act and other corresponding law enforce that the country or specific territory to promote mutual economic relationship, trade and investment. For the avoidance of the double taxation income under the Act, under the corresponding law in force, the country a specific territory without creating opportunity of non-taxation, reduce the taxation through tax evasion avoidance, including territory shopping arrangement, aim to obtain relief products, and that the agreement of the indirect benefit resides on other country territory. For example, central government has notified that where the agreement provides that any income of a resident in India may be taxed in other country, then such income shall be included in the total income chargeable in India. In accordance with the provision of Income Tax Act 1961, the relief shall be granted in accordance with the method of elimination or avoidance of double taxation provision in such agreement. Notification 91 2018, 28 August 2008. For the exchange of information of this prevention of evasion or avoidance of income tax charge under this act under the corresponding law in force in the country or a specific territory or investigation in the case of such evasion or avoidance. For the recovery of income tax act under this act and under the corresponding law in force a country on specific territory, the central government may by notification of official gazette may such provision as necessary provision implemented in category. When the central government has entered into an agreement with the government of any country outside India, specific territory outside India for granting relief or granting avoidance of double taxation, then the relation to the associated whom such agreement applies, the provision of the act shall apply to the extent they are more beneficial to the associate. However, the Act of Chapter 10A and General Anti-Avoidance Rule shall apply to the assessee even if the provisions are not beneficial to him. Meaning of the DTA with the foreign countries and specific territory. Particulars. A term such as DTA is in foreign country and specific territory is not defined in the agreement or the Act, but in this assigning a meaning of notification issued by central government and official gazette which there is still force. Meaning of the item. The term shall have a meaning assigned to some notification, and the meaning shall be deemed to be effect from the date of DTA come to effect of the official gazette. Term DTA with a foreign country or specific territory with the defined in DTA itself. The term shall has the same meaning assigned to it in DTA. The term used in DTA with a foreign country or specific territory which is not defined in the DTA but defined in the Income Tax Act. The term shall be the meaning of assigned to the Income Tax Act 1961 and the explanation if the given to it by the central government. Okay. The DTA under the Section 90 interprets intends to provide relief to the taxpayer who is resident in one of the contracting state to the agreement. Such taxpayer can relieve by applying the beneficial provision or either by treaty or by domestic law. However, in many cases, taxpayers who are not resident in contractual state also restored to claim the benefit under the agreement entered into by the Indian government with the government of other country to affect the other party resident claim to be unintended third parties. Therefore, Section 94 provides a non-resident to whom agreement referred to Section 91 applies shall allow to claim the relief under the agreement tax resident certificate. Section 91 applies shall be allowed to claim relief under the agreement if the tax resident certificate obtained by him on the government of country or a specific territory furnishing declaration as residence of the country outside India or a specific territory outside India, as the case may be. Also, Section 91B provides that treaty shall not be used for claiming reduction tax section through tax evasion or avoidance, including through the treaty shopping arrangement or aim to obtain relief provided in the said agreement from the indirect benefit of residents of any other country or territory. Certificate issued by the government or the foreign country would constitute proof of tax residency without any further constitution regarding the furnish of prescribed particulars therein. In addition to such certificate issued by the foreign government, assessee would be required to provide such other document and information as may be prescribed for claiming the tax benefit. The charge of taxes prescribed to the foreign company at the rate higher than the rate at which domestic company is chargeable shall not be regarded as a less favorable charge or levy of tax expert in the foreign countries. Circular 333 of 24 April 1982 issued by CBD provide that specific provision of the DTA will prevail over general provision of income tax. And however, such there is no specific provision in the treaty, then the income tax act will apply. Generally, DTA is only provides a distribution of tax rights between the residents and the source of state. The computation mechanism is usually not provided in DTA, and the same is governed by the domestic treaty law of the country. Notification 9 2018 and 28 August 2008 issued by CBAT states that the income of the resident of India by which may be taxed in another country, source country, as the may be DTA shall be included in the total income chargeable to tax in India. In accordance with and be included in total income chargeable to tax in India accordance with the provision of Income Tax 1961. Therefore, the relief shall be granted in accordance with the method of elimination or avoidance of double taxation provisions such agreement. Double taxation relief. The tax treaties are generally based on certain models. The most common ones are Model Tax Convention, OECD Model Tax Convention, UN Model Tax Convention. The Model Tax Convention will be discussed in Chapter 27 and Open Model Convention illustration. Examine the correction otherwise to the following statement the reference to the provision of income tax and system. Double taxation avoidance treaties entered into by the government of India overrides the domestic law. That's correct. Section 92 includes that the double taxation avoidance treaties entered into the government. A provision of income tax act would apply to the extent where are more beneficial to the society. In the case of any conflicting between the provision of the double taxation avoidance agreement and income tax system, the provision of DTA will provide over the act viewing the provision of Section 92 to the extent where there is no more beneficial to the society. CITPVAL Kulandagam Chettiar. Double taxation relief is extended to agreement between specific associate adopted by the central government. Section 98. Section 98 provides that a specific associate in India may enter into an arrangement with then specific associate or specific territory outside India, and central government may by notification of official gazette may make a necessary provision for adopting the implementation of agreement. Grant double taxation relief. Avoidance of double taxation income without creating opportunity for non-taxation or reducing tax through tax evasion or avoidance, including through treaty shopping arrangement aimed by obtaining relief provided by the said agreement, but the indirect benefit of residents on other country entity. Exchange of information for the prevention of evasion or avoidance of tax rules or recovery of income tax act. Section 90A1 provides an arrangement may be entered into by a specific associate in India with a specified associate in a specified territory in outside India, which may be adopted by the central government by way of notification in official gazette for granting a tax relief, or the case may be avoidance of double taxation. The central government, we are notified 19/2018, 28/2018 notified that the agreement provides that any income of a resident of India may be taxed in other country, then such income shall be included in the total income chargeable to in India in accordance with the provision of Income Tax Act 1961. The relief shall be granted to the accordance with the method of elimination or avoidance of double taxation provision of the agreement. In relation to the assessee to whom said agreement applies, the provision of the Income Tax Act 1961 shall apply to the extent where the more beneficial to the assessee. However, the Chapter 10A general anti-avoidance rule shall apply to the assessee even if the provisions not benefit him. Meaning of the term used in any agreement which may specify associate in India may entered into by specific associate in specific territory outside India. Double taxation relief. Particulars and meaning of the term used by the any agreement. The term used in any agreement is not defined in the agreement. The Act shall assign the meaning motivated using a central government and official gazette which come into force. Meaning of the term shall have a meaning assigned by said notification in official gazette. Meaning shall be deemed to be effective the date of the notification of official gazette on the agreement come into force. Term used from the date of the agreement, not the official gazette, from the date of the treaty. Term used in any agreement which defined in the agreement itself. Term shall be the same meaning assigned in the said agreement. Term used in any other agreement which is not defined in the said agreement but defined in the income tax, the term shall be meaning assigned to the income tax 1961. Explanation if any given by the central government. DTA under Section 90A is intended to provide relief to taxpayer who is a resident of one of the contractual state of the agreement. Such taxpayer may claim relief by applying the beneficial provision either treating the domestic law, whether or may be the cases. The taxpayer who are not residents of the contractual state who restore to claiming the benefit under the agreement enter into by the Indian government with the government of other countries effect of a third party residing claiming an unintended third party benefits. Therefore, Section 90A4 provides a non-resident whom the agreement referred to Section 91A applies. shall be applied to the claim the relief under the taxation agreement and tax resident certificate obtained from him from the government of the country or the specified territory is furnished. Declaring his residence of the country outside India or a specified territory outside India, as the case may be. Also, Section 90A(1)(b) provides that treaty shall not be used to claim a reduction of tax through the tax evasion or avoidance, including through treaty shopping arrangements, and aim to obtain a relief provided in said agreements or the indirect benefits of the residents of any other country or treaty. Certificate issued by the government of the foreign country while constitute proof of tax residence without any further condition of providing a prescribed particulars therein. In addition to the certificate issued by the foreign government, TRM, tax residence certificate. Section 90A(5) requires associate to provide such other documents and information as may be prescribed in claiming the treaty. One, two, three, four, five, six, 7, 8, 9. Okay, that didn't work out. Okay. Documents information to be furnished by the assessee to claiming the treaty beneficial to CBDT of notification 57. Status of individual, company, firm, etc. Nationality of individual, country, specified territory, territory of incorporation registration, assessee status of individual company, nationality or assessee tax identification number in the country, specific territory of residence in the case of no other number, the unique number in which basis the person is identified by the government of the country or the treaty specific territory which the assessee claimed to be a resident. Period which the resident status is mentioned or certificate referred to section 90A(4), 90A(5) is applicable. 1, 2, 3, 7, 8, 9. The address of the assessee in the country in which specific territory outside India during the period in which certificate mentioned in the period of resident status mentioned certificate referred to the class 94 or section 90A(4). Where the assessee may not be required to provide information or any part therein if the information of the part therefore as the case may be is already contained in the TRC taxation certificate referred to section 94 or section 90A(4). The assessee shall keep and maintain such documents necessary to substantiate the information provided. The income tax authority may require the assessee to provide the said documents in relation to the claim of the assessee and the relief under the agreement related to section 90A(1) or section 90A(1) as the case may be. The charge of tax is higher rate of the company incorporated on specific territory outside India compared to domestic companies, which may be considered as a less favorable or not considered as a less favorable charge or levy of tax in respect to such country. For the purpose of sections, specified associates, nominal means institution, associates body, or incorporated not function under any other time being enforced in India. Law of income specified territory outside India, which may be notified under central government. A specific territory means area outside India, which may be notified by central government. Countries with which no agreement exists. Unilateral agreement, section 19. In the case where the income arising from the assessee in the countries which India does not have any double taxation agreement, relief would be granted. Section 91 provides the following conditions of welfare. Assessee is a resident of India during the previous year in respect to the income taxable. Income accrue arising to him outside India, and the income is not deemed to be accrued arising in India during the previous year. Income in the question has been subject to income tax in the foreign country in the hands of assessee. Assessee has paid tax on the income in the foreign country. There is no charge, there is no agreement that relief from double taxation between India and other countries and the income has accrued and arises. In this case, assessee shall be entitled to reduction from the income tax payable by him. The deduction shall be sum calculated on some double taxed income and the income rate of the tax or the rate of tax in such country, whichever is lower, or the income Indian rate of tax, and both rates are equal. Double tax income on the income rate of tax on the rate of tax which was lower. Important of the meaning of the important terms. The income tax rate of tax means determine the dividing the amount of income tax and Indian income tax after deducting the relief due under the section of the Act, but before reduction of any double taxation is relieved due to the rate of tax on the means the income tax and super tax actually paid in the country is accordance with the corresponding law and force such country have reduction on the duty relief. But before reduction the account of double tax is relieved due to the said country divide the whole amount of the income assessed in said country. Expose income taxes countries during excess profit or tax business profit charge and profit of government as part of the country as a local authority country. Nanthi is an Indian resident and retired employee of the Parasar Bharati 60 is well known in the domestic derived income monitored in theoretical place of growth. The treaty 11,000 to 10,000 11,000 deducted from the country in the place of performance. India does not have any double tax agreement with under section 90 of income tax in the country. Her income amount or the income in India amount to 6,000 view of tax planning. She deposited 1 lakh in the public provident fund and paid contribution over 60,000 and has contribution of 8,000 and she contributed 8,000 to the public. In previous year, gave payment to medical insurance 36,000 and non-resident 84 and healthcare medical non-resident mother non-resident aged 84 and non-dependent who was non-dependent on computed that has liability of Nandiya from the assessment year and assuming opt out of the default tax regime on BSc. So Indian income 6,000 to 4,700,000 and less deduct on 1,50,000, 80,000, 180,000. So aggregate deduction is 1,50,000. Contribution to central government is 28,000. And so medical expense 84,000 is paid by who shall is not entitled to higher education 50,000 is eligible for senior citizen whose deduction is 25,000 max. Insurance premium notice premium for mother medical insurance premium 25,000. Contribution minimum 28,000. Like 50,000 can be. So 2 lakh 3,000, 5 lakh 10,000. So income on this is 10,000. So average rate of tax is 13,000 by 517 is 2%. Average rate of tax in 111 10%. The reduction in the case of 91 is total 11 lakh into 216. Okay. Whichever is lower, it's production okay. Tax payable in India 10,000. Section 80D allows a higher reduction up to 50,000 respect of a medical premium paid to insurance in the health of senior citizen. As for Nandhi has allowed reduction of 28,000 80D which is resident of India age 60. The basic exemption of senior citizen is 3 lakh. The age criteria qualifies as citizen higher rate of IIT according to the Nandhi eligible for. As the is high basic exemption 3 lakhs and since the age is 60 years old. Assessee shall be allowed reduction under section 91 provides the following conditions. Assessee is a resident in India during the previous year. Assessee is accrued arising income outside India during the previous year. Any income is not deemed to be accrued arising in India during the previous year. Reduction and the income is questioned was subject to income tax in the foreign country in the hands of assessee and assessee has paid tax on the income of the foreign country. There is no agreement under section 90 of relief from principal tax agreement between the India and other country where the income has been accrued there. In this case, all the above conditions satisfied and the eligible section 91. Foreign tax credit section 128 of the Income Tax Act 1962. Years of availability of credit for foreign tax paid. As he has a resident can be allowed to credit for the amount of any foreign tax paid beginning in any country as specified territory outside India by way of reduction of the year which the year in which income corresponding to such tax shall be afford to tax or assessed to tax in this manner as the extent of the specified in the rule. However, in the case where the income on which foreign tax has been paid or deducted, it offered tax in more than 1 year. Credit of the tax paid shall be allowed across those years in the same proportion in which income is offered to tax and assessed in the tax in India. Meaning of foreign tax country or specific territory in respect of country or specific territory outside India in which India has entered into the agreement for relief of avoidance of double taxation income in the term section 90 or section 98 tax covered under section and agreement foreign tax. In the respect of any other country or specific territory outside India, the foreign taxes The tax payable under the law tax law in force in the country are specified to in the nature of income before Section 91. For the purpose of income tax referred to any of the country including excess profit or the business profit chargeable to the profit of government on the part of country or local authority in the country. Components of the income tax specified in the FTC available. The foreign tax credit is available against the amount of tax such as is payable under the income tax of 1961. However, it's not available in respect of any sum payable by way of interest or fee or penalty. Manner of computing FTC. The credit of the foreign tax could be aggregated in the amount of credit computed separately from each source of income arising from a particular country or specific country outside India, but shall be given effect in the following manner. Credit should be lower. Credit should be lower at the tax payable under the Income Tax Act on the such income and the foreign tax paid such income. However, the foreign tax paid excess the amount payable in accordance with the provision of the agreement for relief avoidance of double taxation. The excess has to be ignored. The credit must be determined by conversion of the currency and payment of foreign tax at the telegraphic transfer buying rate on the last day of the month immediately preceding the month in which such a tax has been paid or deducted. Now, students should revise section 128 of the income tax of 1991 to end of this module. Okay. Summary and DT relief income tax act 1961 bilateral relief section 90 unilateral relief section 91 agreement with the foreign country bilateral relief. The central government may enter into the agreement with the government or any other country outside India and specific territory or specific assigned outside India for the granting of relief in respect of double taxation income, for the avoidance of double taxation of the income without creating opportunity for non-taxation reduction of taxation through tax avoidance avoidance, for the exchange of information from the prevention of evasion avoidance of income tax, for the recovery of income tax and taxation. Taxation of income tax would be done to the DTA on the income tax act 1961, whichever is more beneficial. Charge to tax on foreign country when the tax or chargeable tax in respect of the foreign company the rate is higher than the rate of domestic company, the chargeable shall not be regarded as a less favorable charge or levy to tax in respect of such foreign company. Tax as in certificate. In order to claim TT relief, the non-resident to whom the TT applies has to obtain TRC tax as in certificate from the government of the country or the specific territory. And non-resident is also provides such other documents and information as may be prescribed for claiming the TT benefits. Unilateral agreement section 91 countries with which no agreement exists. The assessee who is a resident in the India during the previous year condition income accrue arise in India to for him outside India. The income is not deemed to be accrued arise in India during the year. Income in question has been subjected to income tax in the foreign country in the hands of the assessee. The assessee has paid tax on the income in the foreign country. There is no amount for relief from the DT between India and other country which income has been accrued or arisen. Computed relief with double taxation income or Indian rate of tax or rate of tax of the country whichever is lower. Yeah. Concept of permanent establishment under the Income Tax Act 1961, the taxability of the business profit is determined by the existence of business connection in India. Section 91 under the TTA, taxability of the business profit is determined by the existence of permanent establishment in India, which may be noted that the scope of the business connection under Section 91 is wider than the PE. Section 51 of the DTA usually provide that the purpose of this conversion is a term of permanent establishment, means fixed place of business through which a business of the enterprise is wholly or partially carried out. The term permanent establishment is also defined section 92F class 3A of the to include the fixed place of business through which business of the enterprise is wholly or partially carried out. According to Article 52 of a branch, a office, a factory, workshop, a sales outlet, a warehouse, a mine, oil, gas quarry, or any other place existence of a natural sources or not exploring. Permanent establishment of a fixed place of business through which business and enterprise is wholly or partially carried out. Every DTA has a specific clause which deals with the explanation of permanent establishment and the purpose of the DTA. The business income or non-residents will not be taxed in India unless such non-resident has a permanent establishment in India. Taxability of income under the business connection permanent establishment is below. Income of a non-resident. Taxability and DTA governed by DTA on the basis of permanent establishment. Taxability on the income tax are governed by Section 9 on the basis of business connections. Liaison office doesn't constitute permanent establishment. A liaison office engaged in the remittance services. The Union of India is a UAE exchange center. The ITR 30 Supreme Court held that the Indian liaison office of the foreign enterprise engaged in remittance service was not constituted permanent establishment. In this case, no permission is given by the RBA to the associate to engage in the primary business activity or establish a business connection. The liaison office downloads information such as names, address of beneficiaries, amount to the remittance, etc. For by accessing the main server of the associate of the UAE, print and check and draft and dispatches them to the address of beneficiary through courier. The Supreme Court held that even the activities of the liaison office are regarded as a business activity. They are not preparatory to auxiliary characters. Liaison office in the communication channel. The DIT International Taxation via Samsung Heavy Industrial Limited 241 IT and the project office was set up solely on the auxiliary office, the means to act in liaison office between ONGC and SSC. No expenditures related to the execution of contract were incurred by the project office. Only two persons are working in the project office and they are not qualified to perform any core activities of SSC. Therefore, Supreme Court held that the project office is not fixed place of business through which the core business is not carried out. Therefore, the same would not be constituted as a permanent establishment. Identifying new connections, marketing activities, price negotiation, discussion of commercial issues, securing and processing orders as a late in the liaison office of PE. Taxation of business process outsourcing units in India. The provision contained the taxation of IT enables business process outsourcing units are not contained in the Income Tax Act 1961, but Human Circular 5004 dated 28 September 2024 issued CBIT provision and briefly described. A non-resident entity may outsource certain activities to a resident Indian entity. If there are no business connection between the two, the resident entity may not be a permanent establishment or non-resident entity. The resident entity would have to be assessed to income tax on a separate entity. In this case, non-resident entity will not be liable to income tax. However, the possibility of non-resident entity may have a business connection with a resident Indian. In this case, a resident Indian entity would be treated as a permanent establishment of a non-resident entity. A non-resident entity or a foreign company will be liable to tax in India only if the IT-enabled BPO business process operations unit in India constitutes permanent establishment. Non-resident or the foreign company is treated to have a permanent establishment in India if said non-resident or a foreign company carries on the business in India through the branch sales office through its agent or through independent agents who habitually exercise an authority to conclude contract or regularly derive the goods of merchandise and habitually secure orders on behalf of the non-resident customer, such as profit of the non-resident and non-resident attributes in the business activities carried out by India by the permanent establishment taxability in India. If the foreign enterprise carry out a business to another country through a permanent establishment situated there, the profits of the enterprise may be taxed in the other country, but only so such a term is attributed to a permanent establishment. Profit are to be attributed to a permanent establishment as if these are distinct and separate enterprises engaged in the same similar activities under the same similar conditions and dealing wholly independently in the enterprise of the permanent establishment. In determining the profit of permanent establishment, there shall be allowed a deduction expenses incurred in the purpose of permanent establishment, including excluding general admission expenses also include which is the state of which permanent establishment is. The expense has been deductible would be determined in accordance with the acceptable principle of accountancy provision of income tax act estimate. The profit to be attributed to permanent establishment to which the permanent establishment have made. Instead of dealing with the head office, it would be dealing with the entirely separate enterprises under the constitution and the prices prevailing in the ordinary market. This corresponded to arm's length principle. Hence, determine the profit attributable to IT enabled BPO is constituted a permanent establishment. It will be necessary to determine the price of a service entered by the permanent establishment to the head office. From the head office to the permanent establishment is a right arm's length prices. Oh, yeah.